Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. I'm Jeny Maier, and today's episode is It All Connected? Exploring cross-market theories of harm in healthcare mergers. Healthcare is top of mind for consumers, enforcers, and policymakers these days. Most people understand that when major hospitals in the same community merge, prices do tend to increase, and the antitrust enforcers investigate and often take action to block deals. But what happens when the two merging hospitals are far apart? That's what we'll be talking about today. I'm here today with my co-host, Anora Wang. Hi, Anora.
Hi, Jeny.
Can you introduce today's guest for us?
Sure, my pleasure. Dr. Cory Capps is our guest speaker today, who is a partner at Bates White Economic Consulting with 25 years of experience as an economist specializing in antitrust with a focus on the healthcare industry. He frequently advises and offers expert testimony on issues relating to competition in the healthcare sector. Before joining Bates White, Dr. Capps was a staff economist at DOJ Antitrust Division, and before that, he was a professor at Northwestern University's Kellogg School of Management and at the University of Illinois. Welcome to our Curious Amalgam, Dr. Capps.
Hi, it's a pleasure to be here, and please call me Cory. We're going to be talking about cross-market hospital mergers, so I should give both a plug and some credit. The plug is that I have a co-authored article in CPI Antitrust Journal from last year that reviews a lot of the issues that we'll be talking about today, so listeners can always look to that. And that work is co-authored with Leila Caracas and Tatjana Fedko, so I'd like to acknowledge and thank them for their help as well.
Thank you, Cory. And yes, thank you for your great article, which will be linked in the show notes here today. So as you are clearly familiar, and many of our listeners here on the podcast are familiar, one of the U.S. antitrust agency's key areas of focus year in and year out has been healthcare. It's a very significant part of the U.S. economy, and it's an industry that impacts nearly every consumer and citizen in the country. And specifically, the FTC has been very active over the last several decades, scrutinizing mergers of healthcare providers, and most often hospitals. So perhaps to start off our conversation and set the stage, can you tell us what are the traditional theories of how hospital mergers can harm competition?
Sure. Prices that hospitals charge to commercial insurers, other sectors are like Medicare are regulated, but the prices that hospitals charge to commercial insurers for the type of health insurance people get through their employers are set in negotiations. And the hospital threatens to refuse to participate in an insurer's network if it doesn't get a high enough price. Conversely, the insurer threatens to exclude the hospital if the price the hospital demands is too high. And so the bargaining has threat points, and the price usually ends up being somewhere in the middle, and with a network agreement where bargaining leverage determines the prices. And a big question in that negotiation process is, what are the substitutes available to a given hospital? Most patients, individual patients, people like you and me, generally prefer a local hospital. So a hospital faces competition, and insurers trade off against each other, other local competitors to a given hospital when those negotiations happen. So a big part of the FTC's, mostly the FTC, although the DOJ has a few cases here and there, winning record over the last 20 years has been convincing courts that hospital competition is fairly local. Think of 1 or 2 counties in most cases, maybe 4 counties in a more rural area, 30 to 40 minute drive time radii, something like that, where the case would involve establishing a relevant market that's the northern suburbs of Chicago instead of the 11 county Chicago metropolitan area. And that's a big reversal from the 1990s when the courts were adopting very large relevant geographic markets, think all of Chicagoland or 90-minute radius around Cape Girardeau in Missouri, So the FTC and DOJ would allege a 3-2 merger or a 4-2, and the courts would side with the merging parties and find a relevant market in which it was a 9-8 or maybe a 17-16 merger. And that's why the agencies lost a string of mergers. So the important point in that is that the agencies in the 2000s and the teens, and even in some cases in the 20s, although we did see a recent win and abandon a merger in the Novant CHS case where the outcome was to be determined, that winning record was predicated on saying the hospitals compete with other local hospitals. When we get to the cross-market theory, we'll talk about something that's different from that.
Well, then let's go to how the cross-market theory is different. So, we've been talking about how local hospitals in a narrow geographic market can potentially harm competition. How would the cross-market theory work?
Right. So first, what is it? Well, if relevant geographic markets are relatively small, then an in-market merger involves a merger of two hospitals that are in the same general area, a general part of a metropolitan area, say, or the same rural town. A cross-market hospital merger means hospital systems in two such distinct markets are combining. And the question is whether that could also lessen competition through a different mechanism than the in-market hospital mergers on which the FTC has focused over the last 2 decades. And the answer in the economic literature is that it's theoretically possible, and there's some empirical evidence that we'll probably also talk about today showing that cross-market mergers can lead to price increases, possibly through mechanisms rooted in a lessening of competition. The basic idea is that even though no patient who lives in one market would meaningfully consider hospitals in a distinct market to be close substitutes for their local hospitals, employers who draw workers from both of the two distinct markets, so think of an employer with an office in the downtown of a city, the workers could come from the suburbs to the west, north, east, south, as well as in the city. Well, they're going to need an insurance network product offering that offers at least a reasonably good, if not a very good, depending on labor market competition, hospital network in all of those areas. And so that creates, at least in theory, a linkage between distinct relevant geographic markets when you think about it from the employer perspective instead of the individual patient perspective who needs to go to the hospital.
That really is sort of just a different variant of recognizing who the purchasers are and what their needs are in terms of the geographic scope for which they are sort of effectively buying the service. Is that right?
Exactly. And what's complicated about healthcare, maybe even more so than other markets with intermediaries, is that there are two relevant purchasers. The insurer does a negotiation that determines the price at which the transaction will occur. However, the insurer doesn't pick who the consumer will actually purchase from when they need to buy hospital services. Instead, that's chosen by the patient in consultation with their family and their doctor. So the price competition is sort of mediated by the managed care organization or the insurer. The non-price competition is sort of focused on the individual patients. Of course, the two are interrelated.
Maybe can you give us an example of how the price effect could play out in a cross-market merger example?
Sure. If you think about it from the perspective of an employer, they do want to offer a health insurance product that is attractive to their workforce. On the other hand, you can't make everybody happy all of the time. I think that was a wisdom from my grandmother. So if it were to reduce premiums, the costs of which are shared with the workers and by the employer might be willing to say, well, I'll take an inadequate network in one of the, say, 5 areas from which I draw my employees, because that will save money, that will keep, allow wages to grow, firm to be successful, and so forth. And I'll just deal with the dissatisfaction that creates. On the other hand, the employer could logically say, but if I had 2 areas with an inadequate network, that would just be too much. I would lose workers to my competitors, I would be uncompetitive on the recruiting market, wouldn't be able to grow, and so forth. So if you have that set of conditions, then you have an employer who needs to find an insurance product with a good network in at least 4 out of the 5 geographies from which it draws its workers. That actually makes hospitals in the distinct geographies substitutes from the perspective of that employer, because suppose there's an insurance product out there that has a good network in 3 of the 5 geographies. That insurer can say, go and negotiate with the hospitals in the two remaining geographies saying, I only need one of you. I'd love to have both of you, but I really only need one of you. So if you don't give me an attractive price, I will exclude you and go with the other one. And of course, it's playing the same game with the other insurer with the hospitals in the fifth market. So that's the sense in which hospitals in distinct markets can become substitutes from the perspective of their employer, even though no patient is going to consider them substitutes. If you're in DC and you live in Alexandria, I would challenge most people to even name a hospital in Silver Spring. But I think a lot of firms in downtown DC absolutely have workers who live in both areas. So maybe that's a more concrete example.
How did you know where I live?
Well, I don't know which one it is, and you can tell me whether or not you can name the hospitals in the other one.
All right. Well, I will dare Anora to answer and let her ask the next question.
Oh, yeah. I thought you wanted me to name hospitals, which I can do. I've been doing a bit of research recently. But okay, so it sounds like this is all good in theory, but maybe not even that good in theory. But let's go to the research that has been developed so far. There has been some theoretical and empirical research on the quote-unquote cross-market hospital mergers. And you recently, the paper that you mentioned at the beginning of the show, where you and your colleagues summarized some recent academic research on this, I think is very helpful. But let's start with the empirical side. Are there reliable observations? I'm not calling any of the studies that you summarized are not reliable, but I'm just saying, in terms of the evidential value that they have, is there any reliable observations of systemic price increases following cross-market hospital mergers and acquisitions?
I mean, I think it's definitely fair to characterize the literature as showing that some transactions, that there's at least smoke when it comes to cross-market hospital mergers. So there's evidence of price increases across multiple papers from cross-market mergers. However, the various papers differ in when such price effects emerge and when they don't, how long they last, and even the implications or the insights into the mechanisms by which the prices might have gone up. So I think there's a basis to say it's a reasonable concern to have, but there's not a sufficient consensus to say we know what types of mergers have the highest risk of creating adverse price effects through a lessening of competition under the sort of employer-based cross-market theory that we discussed before.
So several papers, I think maybe we can name one or two of those. I think they are in the slowly growing body of empirical research. They're particularly notable. Maybe we can flag one or two and maybe not walk you through them, but tell us what's the major learnings from those papers.
Yeah, well, there are four, and probably I can be quick enough to mention all four. So Kevin Flum and Matt Lewis in a 2017 paper that maybe we can put in the show notes, links to all of these, did find that when a hospital system acquires a distant hospital, prices at the acquired hospital go up by on average 17%. And most of what they were looking at was large systems buying small independent hospitals. Some of those were close by enough where there could have been employers with workers in both areas, and some of them were quite distant, and they all had price increases. So, they speculated that it could be a mixture of two mechanisms. One, the common employer or common customer, as it's also known, mechanism that we talked about so far today. And the other one would simply be that a large, sophisticated hospital system might have a more experienced, more patient, more savvy negotiating team, and an independent hospital might just be taking whatever the payers offer each contract renewal cycle. So it's replacing less skilled negotiators with more skilled negotiators is one of the possible mechanisms they identify. And that's one of the three that we discuss in the paper, and that's called the change in control mechanism for the obvious reasons. What's interesting about that is it's not clearly a lessening of competition, because in general, replacing managers who are less good at manager stuff, whether it's hiring and promotion, quality improvement initiatives, or negotiating prices with payers, replacing less skilled managers with better ones is usually a good thing. So that's Flum and Lewis. It doesn't rule out the common customer mechanism, but it does find evidence of other factors at play as well. Probably the more influential of the four papers is Limor Daphne, Kate Ho, and Robin Lee, 2019 paper in the Rand Journal of Economics. And they really designed their study to hone in on mergers that are likely to have common customers and generate price effects through the employer mechanism that we discussed above.
Right.
And they find sort of nuanced results. They definitely find evidence of price increases from this very specific type of cross-market merger that is likely to have common customers, and that is mergers involving hospitals between 30 to 90 minutes apart and in the same state. They test whether effects persist beyond 90 minutes, and they find weak evidence of transitory price increases, but not lasting price increases. There's another paper by Zach Cooper and a bunch of co-authors looking at the price effects of hospital mergers generally, but sort of along the way, they test the effects of distance between the merging hospitals on the magnitude of the price increase. And they find significant and large price, not that, I guess large is in the eye of the beholder, 6% price increases on average from mergers among hospitals within 5 miles of each other. And then they say, well, how does that change, increase, or decrease with distance?
Right.
And when they get to hospitals that are more than 25 miles apart, they find that there's no evidence of price increases. Now, that's not specifically targeted towards investigating cross-market hospital mergers, but it does at least stand in some tension to the Daphne Ho and Lee result, meaning we need to better understand why sometimes mergers among distant hospitals would lead to price increases, and sometimes they wouldn't.
Go ahead.
The fourth paper was just published, and it's by Arnold and about 7 other authors. And they look at hospital mergers among hospitals that are more than 50 miles apart, just writ large. They don't select them specifically to see whether they might have common customers or anything like that. They just say, let's look at transactions combining hospitals where the most proximate hospitals of the two merging parties are at least 50 miles apart. And they find evidence of price increases from those transactions. And they find a specifically interesting result that hospital systems that buy a lot of hospitals are the drivers of their average result. So if you don't do many sort of cross-market transactions as a hospital system, their estimated price effect is low. If you do 4 or more in their sample, they find an estimated price effect that is high. And again, so in some sense, 3 of the 4 papers are finding some type of evidence of price effects from cross-market mergers, but they're not finding the same type of evidence.
And I'm trying to thank you for walking us through that, and that's very helpful. I'm trying to understand this, from a non-economic, an armchair economist, I guess, perspective. Suppose I observe some price effects, right, from these quote unquote cross market hospital mergers, and I want to explain it from a theoretical perspective. It's I don't know if you heard that song, a couple of years ago. I have a pen, I have an apple, I put them together, I get a pineapple. Here it's sort of like how I'm thinking, economists work. You observe some effects, you try to come up with theories to explain that. And I think your paper that you co-authored, the paper you co-authored, explained 3 mechanism that sort of could possibly explain these price increases. And I know you have already, while walking through the empirical research, you already mentioned them a couple of times, but just to make this even more crystal clear for our listeners. So these 3 mechanisms are changing control, tying, I don't think we mentioned tying that much, and then common customers, right? So can we just briefly distinguish them a little bit and put them in the simplest terms, how those mechanisms actually work?
Sure. And I want to give credit here. I think the first paper to give a nice theoretical discussion of cross-market price effects was Greg Bisney's and Yanis Serafidis from Antitrust Law Journal around 2011. And they discuss at least 2 and maybe all 3 of these. And Greg has a new paper either recently published or forthcoming in the Antitrust Law Journal that gives an update on that from a theoretical perspective. So if you want more details, you can look to those. If you want the quick details, you can just listen to the next 30 seconds. So the common customer mechanism is the one that we went through at some length at the beginning. It just says employers need hospitals in disparate areas, even if patients in one area don't value access to hospitals in the other area. So more distant hospitals can, in fact, be substitutes from the perspective of the employer because the employer is aggregating the preferences of its geographically diverse workers and their dependents. The change of control mechanism is the one we mentioned in the context of Kevin Plum and Matt Lewis's paper, and that's just replacing managers who aren't as good at negotiating high prices, or probably they would say appropriate prices from the perspective of the new managers, with ones who can better negotiate with health insurers. The third one is an old theory. it dates back to the economics and law of regulation. So if you want to, if the government decides to regulate the price of widgets and go to a manufacturer and say the widget cannot cost more than $5. Okay, if I'm a clever monopolist of widgets, in that case, I'm going to say, okay, but I'm going to buy a firm that also sells pencils. And when you have to buy a widget, you also, unbundling it, or actually tying it in this case, I will not sell you a widget unless you buy my pencil. And my pencil happens to cost $10. So it's a way of getting around the price regulation in that context. So that's, I think, a paper called Regulatory Evasion Through Tying by Ward Bowman, circa 1950 something-ish. Applied to the cross-market hospital context, you could have a case where there's a hospital that is so valuable that no insurance product is sellable without that hospital. So that's where you sometimes hear the term must-have. And obviously, exaggerating or simplifying a little bit, because the price can't be $1 billion per hospital stay, but it would have the ability to charge an exceedingly high price, and there may be business or regulatory reasons why it doesn't want to do that. Maybe there's consumer protection laws. Some state AGs have brought actions against nonprofits when they think their conduct is not consistent with their mission, and maybe charging the highest prices in the realm is going to invite that type of scrutiny. So one way to effectively achieve a price increase without raising prices to an exceedingly high level is to buy an outlying hospital. It could be a nearby hospital, but maybe that gets you an in-market merger challenge. So to avoid that, you could buy a hospital an hour or two away, or several of them, put them all together as a bundle and only sell them at once. So this is like our widget and pencil maker, and raise the price of the acquired hospitals above what they had been charging before, but probably still below the level of the hospital with substantial market power that we're hypothesizing here. So that takes a more specialized set of circumstances, because you have, a specific hospital that for some reason has the technical value to raise price, but some external constraint on its willingness or ability to do that. Some components of this were present in the state of California's Sutter investigation.
We might mention that later in more depth, but just just to put an even higher level stylized summary of this. So for these mechanisms to work, there has to be some conditions present, right? And then maybe not so much focusing on tying and changing control, because that's perhaps not so unique in the situation that we're so concerned about today, right? So common customers seems to be the theory that's mostly behind the concerns behind cross-market, at least for hospital mergers. Could you tell us what are the necessary conditions that would make this common customers mechanism to be more likely to work to cause price increases following cross-market hospital mergers?
Sure. I will speak to my idea of what is, or perhaps should be, a consensus among economists who look at this topic. That doesn't mean I actually speak for them. And, some of them might say, look, we know these types of transactions are going to lead to a price increase, and so we don't care about the mechanism. That's not really, to me, a Clayton Act Section 7 statement, but rather a policy prescription, more in the legislative or state arena. So I'll give my thoughts on what it takes for a common customer mechanism to lead to a lessening of competition.
Right.
And I think we really are in the realm, because of some of the ambiguities in the research literature, where we have necessary conditions more so than sufficient conditions to identify it. Meaning, if you don't have these things, then there's unlikely to be a strong case. That doesn't mean if you do have them, there's necessarily a strong case. It takes a lot of work to go from should we issue a second request to we're going to file a challenge, and then even farther to winning a challenge. So the common customer mechanism does relate to competition. It actually posits that hospitals are substitutes from the perspective of employers, even though they're not from the perspective of patients. That's why, if you've heard Aviv Nevo give a speech over the last year or three where he covers this topic, he always states now that he doesn't like the term cross-market. He alleges that they're substitutes. They're in the same market, and so we should find another label for it when we think about it from the employer's perspective, and not the patient perspective. So what do we need? If it's a common customer mechanism, we need the hospitals to have customers who are common. Meaning, if you look at the employers that send patients to hospital system 1 and hospital system 2 in a cross-market merger, you should be able to find some of the same employers in both hospital systems' billing records, which you could look at through the hospital's billing data or even through insurers' data. And then the question is, well, okay, I'm sure for any two hospitals of size that are within an hour or two of each other, you're going to find at least one patient at each that worked for the same company just by random chance. So you probably want more than one patient who's covered by a common employer.
Right.
If most of them are covered by common employers, and that's pretty strong evidence that the mechanism could apply. And so where between one patient and most patients do you say that you have enough common customers? And I don't think we have a good answer to that. We just know that fewer, at a very small proportion is probably inconsistent with the theory. And the more you have, the more likely it is that the theory is to apply, and vice versa. So looking at and documenting and establishing the extent of common customers is one important predicate for that. And you would have to show a meaningful volume of those. The second is, this is premised on the idea that in multiple geographic areas, if you didn't have the cross-market merge system in your network, you would have, as an employer, unhappy workers in two distinct areas.
Right.
And the insurer doesn't want to offer a product that has a gap like that in two distinct areas.
Mm-hmm.
So the absence of the hospital that are relevant in market one has to be important to consumers in the area where hospital one competes. So that's to say there has to be some degree of market power, not maybe what antitrust practitioners would consider monopoly power, but at least some meaningful degree of market power on the part of the hospital that's located in market one. And then for the exact same reason, for the hospital that's located in the other market, it has to be important enough that its absence would be meaningfully disruptive to employers and their workers. And there's some debate on this. You can find people who've written that there needs to be market power in only one of the markets implicated by a cross-market merger. But I think really, if you're tying it to the common customer theory, you need at least two or more distinct relevant markets in which with each system that's part of the cross-market merger having market power in at least one geography.
Right.
It gets complicated in the real world because you might have one system in 5 geographies acquiring one in 2. It's not always single hospital plus single hospital.
Right.
The third condition is that the markets aren't separable, which is kind of maybe an ambiguous term when you first hear it. But if the markets are so far apart that the set of insurers that most employers use in market one are different than the set of insurers that most employers use in market two, then the markets really aren't linked in that way, right? Because insurer one, insurers in region one negotiate with the hospitals in region one, and neither of them have any thought to what's going on in region two, and vice versa. So you need some meaningful extent overlap between the two markets, and you need a related way that markets can be separable is if most of the employers are offering menus of plans from different insurers, so that employees in region one, can pick a network that's good for them in that region, and employers in region two can pick a network that's good for them in that region. Then a hospital system that withholds both doesn't really gain additional leverage relative to a hospital system that's able to withhold just one. To make that a little bit more concrete for people who've gone through the agencies, FEHB, the Federal Employees Health Benefit Program, has a large menu of plans that people can choose from. And if you live in California, you might choose Kaiser or Blue Shield of California. And if you live in New York, you might pick, United Healthcare or Aetna.
Right.
And then I would say the fourth condition that's a little bit less obvious is that the hospitals in the cross-market merger have to be substitutes from the perspective of employers, not complements.
Right. Well, that's a lot to digest, and not to repeat what you just said, but you think the volumes of common customers has to be meaningful first, and second, the merging systems need to have some degree of market power in at least 2 distinct relevant and geographic markets, and then third, markets are not separable, and then fourth, the hospitals in such a cross-market merger should be substitutes, not complements. But I think there is an elephant in the room, right? And we talked about that, right before we push record button, is that this is not something, this is a phenomenon perhaps in U.S. only, right? It doesn't happen a lot or maybe ever in areas outside the US where there is a different healthcare system. Is that so?
First, that was a good summary. I agree. Much more concise than mine. Well done. Second, yeah, at least for the change in control, right, it's premised on employer-sponsored health insurance, which, to my knowledge, is mostly or entirely unique to the United States. So this type of mechanism wouldn't arise in any country without employer-sponsored insurance. The change in control or tying in the right circumstances may be applicable elsewhere, but not the substitutes from the perspective of employers phenomenon.
Maybe let's just jump to the sort of $1,000,000 question here is these phenomenon and the research that you have been talking about are all sort of relatively recent, and how, if at all, have the agencies been internalizing the research and the theories? What cases have the agencies investigated, and have they pursued any cases based on these theories?
Yeah. So focusing on DOJ and FTC, and it's mostly the FTC these days on the hospital front, but still not entire 100% market share for the FTC. I think it's good for the competition agencies to compete. The FTC is public. It's public that the FTC has investigated at least 2 hospital transactions on cross-market grounds. One was Beaumont Spectrum in Michigan. Those are over 2 hours apart. Spectrum's in Grand Rapids and Beaumont is in Detroit. So that's outside the 30 to 90 minute range that we talked about before from Daphne, Ho, and Lee. They did not challenge in that one. And then the second one they investigated was Atrium, with its roots and headquarters in North Carolina, but hospitals in surrounding states merging with Advocate Aurora, which had hospitals in mostly Illinois and Wisconsin. So the FTC it's public that the FTC investigated that one, and also that they did not challenge. So both, it's hard to come up with a theory in which the FTC would have investigated either one other than cross-market. So although they didn't publicly state that to my knowledge, but it is clear that they didn't challenge.
That's really interesting. And thinking then, again, continuing to look forward, if you were to find yourself sitting inside the Federal Trade Commission, what do you think would make for a compelling cross-market enforcement action case?
Well, I think you would want to hit all the predicates that we discussed a few minutes ago, and you would want to hit them by a wide margin. It would certainly help to have some documents. That the technical term, by the way, that economists use to describe hospitals that are distant being far apart is concavity of the value function. In case you ever hear Aviv or someone else, Greg Visney's talking about these, you are not going to find as an enforcer a document that refers to concavity of the value function. But you may find business statements that, in substance and effect, are describing something about employers really needing hospitals in both geographies implicated by the market. I personally haven't seen such a document, but it would probably help a lot with the novel theory to have it written down in the course of business. And you maybe as an enforcer could look to that from both insurers and hospitals and find that. I think maybe another predicate would be, sometimes systems will have a track record, and you might say this merger looks a lot like this other merger that another system in the same market did, or maybe the same system in the same market did in the past, and you could look to that to see what happened as a anecdotal, meaning it's a sample size of one, but a test of the theory.
Well, I think that's all very helpful. Based on the caveat that, some of the research, or maybe even all of the research that we mentioned, are relatively recent. They're circa 2017, 2019, and then maybe one more recent. And then the history of federal agency and state enforcers trying to pursue this theory is not that thick, and perhaps not validated in court at all or ever. So do you think there is any additional or maybe a lot of additional empirical research that could be done to advance the agency's ability to make appropriate enforcement decisions?
Sure. Although actually, I want to add one more point on the prior topic and then come back to research, which is When you think about the agency perspective in the room, you also have to look at the business needs of the hospital at issue and the community. So if we look at CHS Novant, which was the one that the FTC just lost at the district court level, they got an emergency stay from the Fourth Circuit, and then the hospital said we quit. So the judge basically sided against the FTC because it said this hospital has a dearth of investment historically, and that's not going to change so long as it's under CHS's control. The FTC said CHS is a close competitor in the Lake Norman area to Novant, and so we don't want that merger to happen. Well, if they don't want that merger to happen, and the hospital is not being effectively run under CHS, as the judge basically found, what else can happen? Well, you want a buyer that's not Novant, which is going to be, unless you want to refile the same antitrust lawsuit as the FTC, an out-of-market buyer. So another consideration that's going to have to go into the FTC's thinking is, would I prefer an in-market buyer or an out-of-market buyer? Not what I prefer, but what do they think is going to most benefit competition and consumers? So there's another, maybe a fifth or sixth, I forget how many prongs we had before, to that question. Now I can turn to the research question. I do think that where there are differences between papers, as there are in the cross-market literature, there is always going to be room for more literature. There were more papers looking at horizontal hospital transactions over the course of the 90s, a lot of them generated by what the courts were doing and siding against the DOJ and FTC in a string of cases. There were more papers on that question where the theory was not that novel. The question just was over what geography do hospitals really compete. There were more papers in that area than there have been in cross-market. So you take a simple question, has a dozen papers. A more complex and novel question has, in some sense, 4 empirical papers. So there's definitely room to do more. One slight problem, the incentives in academia are to do something fully novel a little bit more than to sort of say, let me see if I can reconcile these 2 papers. But I think either could make something novel or answering or resolving some lack of congruity in the research literature could still add value. So there's work to be done by, say, grad students or academics on that front. And then another avenue, especially more relevant to the FTC and the DOJ, is 6B authority. So the FTC did issue CIDs to 6 health plans in 2020. The specific focus was the effect of consolidation in the physician sector, horizontal and consolidation of physicians with hospitals as well, vertical integration basically. But to my understanding, I think the data there would be sufficient for the FTC to study other questions as well. And so we know that the Bureau of Economics can and does sometimes release retrospective studies based on 6B data. So if you go back 20 years, there was a set of papers that came out of the hospital merger retrospective launched under Chairman Muris, I believe. That definitely was Muris. So it's possible, although they've been pretty busy these last few years, but it's possible at some point that we may see more research in either direction coming out from the FTC.
Cory, thank you. There is certainly no shortage of papers to read, and we have a nice way of segueing out of our substantive conversation here today. And you are very busy at ensuring that you understand and can explain to us the ins and outs of how healthcare economics works, but we want to get to know you as a person. Can you tell us and our listeners something fun about yourself that we wouldn't know if we only knew you in the professional setting?
Let's see. Historically speaking, I'm a semi-competitive, not quite pro-level pool player. So that's a little bit novel. Although some people would know me professionally from that because there was once a economic analysis group pool team that included myself. I don't know, maybe I won't out them all now. But we had a group of 5 of us, and we were quite successful for a while. These days, though, I end up playing more squash than pool.
Okay, well, we will watch out for you at the pool tables, at the bars, at the spring meeting. And the way that we like to end all of our episodes is through a fun little game that we call the Curious Hat.
And now it's time for the Curious Hat.
This game couldn't be any easier. I am going to pick a random question out of my imaginary hat here. And your question today here is, if you could have front row tickets to any concert, sporting event, performing arts.
Texas Longhorns, College Bowl Football Championship 2025. That was easy.
All right, that's a definitive answer. All right, well, hook 'em horn. Cory, thank you. Really appreciate you taking the time to talk with us. And we look forward to seeing all of our listeners next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.